2022 CR 3873B and 2022.
Right from the start, this case carries massive stakes. Aggravated robbery in Texas is classified as a first-degree felony, meaning the punishment range can stretch all the way from 5 years to life in prison. When a judge mentions that range early in a hearing, it's a clear signal to the courtroom that the consequences here are extremely serious. The big question is, will the plea deal protect the defendant from that maximum sentence, or could things still take a dramatic turn later?
CR 3498B, State of Texas versus Philip Washington. Can I have parties approach and announce for the record for the state?
Brian Germer for the state of Texas.
For the defense? And are you Mr. Washington?
Yes, ma'am.
Defense, in each of the cause numbers, I'm showing you what's entitled acknowledgement of discovery. Did you review all the discovery in this case with your client, and have you received all the discovery?
Yes, I have.
Then each of the cause numbers, the court will find that the state is in compliance with discovery. Mr. Washington, in each of the cause numbers, I'm showing you what's entitled true bill of indictment. Did you review those documents with your attorney? Did you understand them?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented in cause number 2022 CR 3873B?
Judge, is that the one with 2 counts?
No, that's the one with the repeat enhancement allegation.
On that one, Judge, we're just waiving the repeater enhancement.
Any objection?
No objection.
And then in cause number 2022 CR 3498B, are you proceeding on the indictment as presented?
On that one, Judge, I believe there's 2 counts, correct?
Yes.
We're proceeding on count 1, waiving count 2, and also waiving the repeater enhancement.
Any objection?
No objection.
This moment is extremely important in any criminal case. The judge is confirming that the defendant understands the charges, the evidence, and the rights he is giving up. By accepting a plea deal, the defendant is waiving the right to a jury trial, meaning 12 jurors will no longer decide his fate. Instead, the outcome will largely depend on the judge and the agreement negotiated by the attorneys. But here's something worth thinking about. Would you take a plea deal for 22 years? Or risk going to trial and potentially facing life in prison? Let me know what you think in the comments.
Mr. Washington, in each of the cause numbers, I'm showing you what's entitled court's admonishments and defendant's waivers and affidavit of admonitions. Did you review those documents with your attorney? Did you understand them, and did you sign them in all the appropriate places?
Yes, ma'am.
In each of the cause numbers, the state is proceeding on the aggravated robbery count. That's a first-degree felony. The range of punishment is anywhere from 5 to 99 years or life in prison. Did you understand?
Yes, ma'am.
And up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargaining agreement with the state, the court does not have to follow your plea bargaining agreement. If for any reason the court does not follow your plea bargaining agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargaining agreement you were giving up those rights?
Yes, ma'am.
Okay, you need to speak up.
Yes, ma'am.
And did you intend to give up those rights and enter into a plea bargaining agreement in each of these cause numbers?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
He has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, ma'am.
Mr. Washington, has anyone threatened you, coerced you, or placed you in fear to get you to enter into these pleas?
No, ma'am.
Has anyone promised you anything other than the plea bargaining agreement?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
In each of the cause numbers, the court will find that the defendant has knowingly and voluntarily waived his right to jury trial. And each of the cause numbers, I'm showing you the plea bargaining agreement. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
According to the plea bargaining agreement, the state is only proceeding on count 1 in each of the cause numbers. Punishment is to be assessed at a cap of 22 years in the prison. There's an affirmative finding of deadly weapon, a $500 fine. There are no applications. Each case will run concurrent with each other. The state will take in consideration 2022 CR 3499B, JN number 2049196, 2076193, 2022 CR 3501. And you are in agreement that you committed these offenses with co-defendants. There's to be no contact with Cassandra Acosta, Jorge Colmenares, Brenda, for the record, that's Colmenares, Kenneth Henry, and Cynthia Maris, Mares. Did you understand that to be the plea bargain agreement in each of these cause numbers?
Yes, ma'am.
Defense, is that the plea bargain agreement?
It is, Your Honor.
State, is that the plea bargain agreement?
It is, Judge.
Next, I'm showing you the paragraph entitled waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it, and did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
There is not.
And if I can have parties approach. In 2022 CR 3873B, you all have outside the agreement the no contact order. But in the other one, it's inside the agreement. So I'm assuming that's the agreement. Is that correct?
It's just the no contact with the victims of the case. I think I put it on one and Brittany might have moved it down.
That's fine. Either way, Judge.
All right, thank you. So, Mr. Washington, in cause number 2022 CR 3873B, you understand that outside the plea bargain agreement is the no contact order with Cassandra Acosta.
And there it is, the defining moment of the hearing. The defendant enters two different pleas, no contest in one case and guilty in the other. A no contest plea means the defendant isn't formally admitting guilt but also isn't fighting the charge, allowing the court to treat it like a conviction. Strategically, this can sometimes be part of a negotiated deal. But the story isn't over yet. Even though the judge accepts the pleas and finds sufficient evidence, the final sentence hasn't been decided. A pre-sentence investigation report will now be prepared, and that report could heavily influence how many years the defendant actually spends behind bars.
Jorge Colmenares, Kenneth Henry, and Cynthia Maris. Do you understand that in cause number 2022 CR 3498B, that is a part of your plea bargain agreement, that you have no contact with those persons? Did you understand?
Yes, ma'am.
And do you understand that if the court accepts your plea bargain agreement, the court is going to order in both cause numbers that there be no contact with Cassandra Acosta, Jorge Colmenares, Kenneth Henry, and Cynthia Maris? Do you understand?
Yes, ma'am.
Then in cause number 2022 CR 3498B, to count one, how do you plead? Guilty, not guilty, or no contest?
Guilty.
And in cause number 2022 CR 3873B, how do you plead? Guilty, not guilty, or no contest?
Guilty, Your Honor.
All right, you pled no contest in 3498B, and you're pleading guilty in 3873B?
I think he said guilty on both.
Guilty.
Oh, okay, thank you. Sorry. Brenda, is my hearing leaving me?
It's lunchtime, Judge.
You're like, you don't know how to respond to that. How do I respond to
I
that?
wrote guilty, so I don't-
All right, thank you. She's not even, see, she's a good co-reporter. She doesn't even protect me on the record. She's like, I couldn't hear it either. All right, state any evidence support the defendants, please.
Yes, Judge. State would offer State's Exhibit number 1 and all attachments.
No objections.
All right, Mr. Washington, each of these cause numbers, I'm showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review those documents with your attorney? Did you understand it? And did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand today that the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony?
Yes, ma'am.
Then in each of the cause numbers, the court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same.
Yes, ma'am.
All right. In cause number 2022 CR 3873B, court is finding there's sufficient evidence and the court is finding you guilty. All right. So we'll come back On that date, Mr. Washington, August 15th, and at that time, the court will sentence you.
Yes, ma'am.
And the sentence will be based upon the report I received from PSI and any other evidence that is presented. Do you understand?
Yes, ma'am.
All right, thank you.
Please drop your views in comments section and subscribe for more interesting cases. Thanks for watching American Justice Files.
The courtroom session begins as Judge Stephanie Boyd calls 2 felony cases against Philip Washington. The charges stem from aggravated robbery, one of the most serious violent felony offenses in Texas. As the hearing opens, attorneys for both the state and the defense formally announce their appearances while the judge confirms the defendant's identity. Judge Stephanie Boyd immediately begins reviewing procedural matters. The defense confirms that all discovery materials have been received, and the judge formally rules that the state has complied with discovery requirements. From there, the court moves to the indictment review, ensuring the defendant understands the charges brought against him. The prosecution clarifies that in one case they will proceed on a single count while waiving certain enhancements. In the second case, they proceed on count 1 of the indictment, again waiving additional counts and enhancements. The focus remains on aggravated robbery, classified as a first-degree felony. Judge Stephanie Boyd then delivers one of the most critical warnings of the hearing, the range of punishment. She explains clearly that the offense carries a possible sentence of 5 years to 99 years or even life in prison, along with a possible $10,000 fine. The judge ensures the defendant understands he is giving up his constitutional rights, including the right to a jury trial and the right to confront witnesses. Washington confirms he understands and proceeds with the plea agreement. Under the agreement, the state recommends 22 years in prison, with both cases running concurrently. The deal also includes a deadly weapons finding, financial penalties, and strict no-contact orders with multiple victims. Judge Stephanie Boyd carefully verifies each element of the agreement before accepting evidence in the form of police reports and witness statements. After reviewing the evidence, she formally finds the defendant guilty in both cases. However, the process is not finished. Judge Stephanie Boyd orders a pre-sentence investigation report, PSI, and schedules a future hearing. The final sentence will be determined after reviewing the report and any additional evidence presented in court. The courtroom leaves with a looming reality. The defendant's fate now rests in the judge's final sentencing decision.